wave. Hi, Emily. Hi, Emily.
Hi.
All right. I want to take us live.
You are.
We are live. Welcome, everybody, to House General and Housing. Today is Tuesday, April 29th, 2025. We're going to hear two bills this afternoon. One is House 348, which is about protecting workers from extreme temperatures in the workplace. And we will be taking an additional testimony, but this is the beginning of our testimony. And then after that, we're going to be returning to H-169, which is an act relating to amending the prohibitions against discrimination in public accommodations in housing. And so let's start with H-348. We have two witnesses with us. One is with us electronically, and one is with us in person. So what I think I'm going to do before you guys introduce yourselves is have the committee introduce itself to you. Want to start?
Absolutely. Good afternoon. I'm Ashley Bartley. I serve Fairfax and Georgia.
I'm Leonora Dodge. I serve Essex in the city of Essex Junction. Good.
Joe Parsons, Newbury, Thompson, Groton.
Hi, Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Debbie Dolgan, St. Brownsbury, Concord, and Kirby.
Gal Pezzo, Pittman 20, Colchester.
Mary Howard, Rutland City, District 6.
Hi, I'm Elizabeth Burrows, and I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
Hi, Claudia Lamont, Memorial Washington, Morristown, Elmore, Worcester, Woodbury, and a small part of Stowe.
Wow. Emily?
Emily Krasnow, Chittenden 9, South Burlington.
Hey, you sound pretty good, Emily.
Yep, sounding better.
Good. Mark Mahaly. I'm chair and I represent Plainfield, Marshfield, and Calais. So, Curtis, are you here?
Yes.
Want to have a seat? Introduce yourself to the committee. Are you and Bridget gonna be one following the other?
Yes.
Okay. So, Curtis, you want to introduce yourself to us and talk to us?
So my name is Curtis Clough. I'm the president of Teamsters Local 597 in Vermont. You all announced your districts. My district is Vermont. That's where I represent the Teamsters. And I just want to start off with telling you I appreciate you taking the time to, think about what we think is a very important issue. And I also want to say how much I appreciated during the introductions that you gave us your name, you gave us your district. You didn't tell us what political party you were from, because really we think that on an issue like this, workers' rights and worker protections, it's important that everybody across the political spectrum really understands the type of changes that are happening in the state of Vermont and understands, that there is a need to address some of these issues. So I'm going to guess there's a lot of long-term Vermonters in the room, maybe some shorter-term Vermonters, but as we've seen bigger and bigger companies come into the state, there's been a lot of loss of direct connection to the employee. So it isn't quite the same level of interplay between the person that actually makes the decisions and runs the company as there used to be, and the actual people that they employ. So Vermont, everybody in Montpelier, I'm sure, can appreciate just how much of an effect the climate has had in the last few years and how things have changed in the state of Vermont. Right now, it's 80 degrees. I didn't grow up in Vermont. I grew up in New Hampshire. But in New Hampshire, you didn't get 80 degrees until it was June. This isn't the first time it's happened in May, but it doesn't happen in May all the time. And, that has a big impact on the people that work in the state of Vermont. There used to be a few days every year where you'd have some heat. It would slowly get warmer over the course of the summer, but you'd have a little bit of time to adjust to it, and it didn't get as hot as it does now. And what you used to be able to do was engage in a little bit of, self-acclimatization. Some companies embraced it a little bit early on, but you just don't have the ability to do that anymore. And the state really has an opportunity here to come in and set some guidelines and standards for how companies interact with their employees when they do face extreme climatic conditions. I worked for UPS for close to 20 years. I worked in a warehouse that was technically had a heater, but when you went into the warehouse in the morning, it was almost always below zero when it was below zero. That isn't, believe it or not, that isn't a working condition that the state of Vermont actually has any regulations on the book. If we wanted to get some if we wanted to get some help from, a safety entity in the state of Vermont, we had to go look around the warehouse and find laws that they actually would enforce. People's water bottles were freezing. There's not really any regulation to deal with that in the state of Vermont. The water fountains would freeze. There's not really any regulation to deal with that in the state of Vermont. We had to go and look around for things like emergency eye wash fountains that would freeze, and they still do freeze. We were at an employer earlier this year who had gone to Walmart and taped a box of saline to the emergency eye wash station that was next to where they process the hazardous chemicals whenever whenever a box of hazardous material is damaged and needs to be processed for containment. So somebody who is injured in that manner would have to, pop open this eye wash container. And that's what it took to get OSHA to actually come in and say, hey, this is actually, that was the working condition that we had defined to get the state of Vermont, establishment to take it seriously and say, hey, this is a safety issue. And it doesn't really need to be like that. I mean, people should be able to go to work and not have their water bottles freeze while they're there on a shift. That seems like a reasonable working condition to me. There's a lot of people in here with water bottles. It doesn't seem like it should be out of this world that you should be able to go to work and not have to worry about that. In Vermont in 2025, it isn't like when I first started working for UPS. When I first started working for UPS, you could sit there and idle your truck, during a cold winter day. I have asthma. When it gets below 5 degrees or so, I start to have trouble breathing outside. UPS driving is an outside sport. You could keep your truck running and get away with that. That's not the case anymore. For good reason, there are idling laws in place. And this Worker Protection Act would give the state the ability to set a temperature at which, companies would have to have an auxiliary heater. A lot of companies do that already in Alaska. And that would mean that people who can no longer idle their vehicles, coming from a truck driving background, it wasn't ideal to have your vehicle idling, but the alternative was your water froze, your coffee froze. You had trouble breathing if you're me. But when you get out there in the road and, you're trying to deal with sensible, changes that have happened to the law to make it so that you don't have diesel vehicles idling all the time. There wasn't that other aspect of it, which we feel like this bill can bring into play, which is having that auxiliary heater in a vehicle and telling companies that they have to have that auxiliary heater. That they should be, when employees are outside in 5 below, it's a company's obligation to make sure that those employees have the tools that they need to adjust to those working conditions. We know that it gets that cold. We know that, people out there working for the power company, sometimes it does get cold in the winter. They do have to, they should be allowed to take breaks in the vehicle to warm back up. There should be a minimum heating standard in a warehouse. It's not an unreasonable, thought process. And as the temperatures do change and the climate does change, we're seeing more and more of these hot days. We have noticed in the last 3 years at one of our locations, and, they generate some of their own heat. They process milk, which means they pasteurize it at 160 degrees. They've seen, 10, 15, 20 days where their heat index was, in the red. That's as measured by a wet bulb thermometer, where there was nowhere that people in the plant in their work areas were able to get to a place where it was, under that 100-degree threshold. You know, it's very hot. And this bill gives, you know, the state the opportunity as the climate gets warmer to kind of put a cap on that and say, you know, we know things are changing on the outside, but things need to remain the same on the inside where you're not working in 100-degree weather. You were just, I had the privilege of listening to the conversation in here about, you know, the way the temperature can fluctuate in these buildings. And it's no different in any employer or any work site in the state. You know, this bill will set a standard where when it is too hot, employees will have the right to, you know, go sit in the shade. They'll have the right to go to a cooled area. When it's too cold, they'll have a right to go somewhere where it's warm. You know, they'll have a right to safety equipment. And, you know, some people have some people are lucky. They're self-employed. They get the ability to make their own terms and conditions. If they get too hot, they can say, well, you know what? I'm going to go sit inside where it's cool for a few minutes. But most people in the state don't have that. They work for somebody else. A lot of the time they're working for somebody out of state. They're not working for that family business that they might have worked for 40 years ago. And they don't, you know, that person might be running things from an air-conditioned office in Tennessee, and they might not know that somebody needs to, you know, come inside because it is 80 degrees for the first time in the year in Vermont. And these people are working hard and they're not acclimatized to that. And that's when a lot of these heat injuries happen. So this bill, we think, is a nice comprehensive bill that will address heat injury from a lot of different angles. It will also help as we have more corporations come into the state that are running things from out of town. You know, we've received outreach since we started this project, even from people that work for ski areas. These ski areas used to be, you know, locally owned. Now they're owned by Vail or other out-of-state entities. They've worked for them for a while. They know how things have changed. We rely on a lot of immigrant labor at the ski industries. They used to issue them winter boots. They used to issue them jackets. Not all of them do that anymore. They used to have working conditions where they would, you know, follow the manufacturer's recommendation, where they'd have two people on a lift, one person assisting on the lift, one person in the bunkhouse running the lift, and they'd trade off every 30 minutes. Now they're having them operate those lifts from the outside. So they're seeing people standing outside for 8-9 hours. If they have enough staff, they'll get one lunch break to go inside. So it just isn't the same. And that's, you know, part of what we think we need to acknowledge, that things have changed in the state, things have changed with the climate. And, you know, I appreciate you all taking the time to listen to this issue and listen to us testify about this legislation. I'm happy to answer any questions that anybody has.
Questions by the committee? Tom?
Do we have this yet in anything other than the short form that was read?
Sophie, our counsel, is working on it.
Okay.
But we don't have it yet. And it will be apparently a substantial piece of work. Did you have a question?
Not for you. I'm so grateful for you coming in. I think it'd just be nice for our friends who are in here, who aren't in here every day, to know what we're doing, or has that been explained?
No, I think you should explain it.
That's great.
Yeah.
Yeah, thank you. We appreciate it.
Of course, I'll go really quickly. But so what happens when a bill comes to us, either in the House or in the Senate or on the House side? It is our responsibility to, if you look behind you, there's all of those bills. And we, as a committee, decide which ones to take up and which ones not to take up. So this is one of the bills that is on our wall. 334, 348, 348.
Yeah.
And so what we do as representatives and how we do our work is we have individuals come in with either lived experiences who really understand and have, you know, they might have opinions or concerns, and they come in, they testify, and then they are gracious enough to answer our questions. And then what we can do with once where we ask our questions is normally after the fact, we all sit around this table and, you know, might ask each other questions or have a conversation on what way we think is best. So that you're really kind of seeing the start of how a bill is worked on. So that's what we're doing here. Very, very brief.
Will the bill get to the actual House floor without you all approving it?
No.
No. So if at the end of this and we take a vote and the bill is voted unfavorably, it does not make it to the House at all.
Unless it's a floor amendment.
Unless. Now you just made it complicated.
You better explain that, yeah.
But, so just very brief on kind of what we're doing today.
I'd like to add that there are 16 places that a bill can die between when it's first conceived of and the House and the other body, which is this, for us, the Senate. And then there's another 16 places it can die in the Senate. And then if it passes both of those things, then it goes to the governor. And then the governor may sign it, the governor may not sign it.
Excuse me, so sorry.
There's that.
Or the governor may veto it, which is, say, that's another place it can die. And if he vetoes it, then if we have the votes, if we are really insistent about it, we can override his veto. But there are a total of something like 36 ways for a bill to die. And when you think about it, it's.
Or morph.
Yeah.
Many of those places, they can change it.
Yeah. And when you think about it, when you think about the fact that we are making a law, we're not just making a rule, we're making a law. It probably should have that many places to die. So.
I have one question for you, Curtis.
Also.
You got a question? Oh.
I've
Emily.
had my hand up.
Well, you go before me, Emily. You have a
Um,
question for Curtis?
Well, no, I just want to thank Curtis for coming in. I know how hard he's advocated for this and all of his members, and I strongly support this legislation and look forward to seeing how the language shapes up after it's fully written. But I appreciate you taking the time to come in today, and I hope that we continue to work on this. Is very important as you mentioned, as climates change and things change. I really think this is an important protection for workers. Thank you.
Thank you. Yes.
I'm so sorry. Can I ask, so listening to Emily, it sounds like you've been advocating for this for a while. And we haven't seen the language yet. Is this just for extreme temperatures? I think most of our communities were impacted by flooding the last 2 summers. In your conversations, has something like that come up, like extreme weather events? Or is it specifically just for, extreme cold or hot?
So as far as extreme weather events, there is some, we have talked about that, but our thinking was, well, sometimes companies are a little cavalier. There's actually already, it's kind of like a workplace violence event, right? You can't control a lot of it, but they still have the duty to protect people from a workplace violence event. And we've seen, so we have had the question, but we kind of feel like there is some ability to address it, but we haven't really put together any long-term plan of how.
Okay, so the focus is really just the temperature.
Absolutely.
Thank you.
Other questions by the committee? Yes.
Not so much a question, but I concur with what Representative Krasnow has said. And so thank you very much for coming in and testifying. So many of us don't know what goes on the outside, so it's good to hear it. Although we're very familiar with corrections and the situation in our corrections buildings where they have had no air conditioning and people have been sent to the hospital. And, with the climate change, we definitely have to do something about that. You can't ask people to work under these conditions. It's inhumane, really. So thank you again for coming in. Appreciate your testimony.
Curtis, do you have any thoughts on how this would work? In other words, the kinds of things you talked about, trade-off, relieve safety equipment, cooling off breaks, warming breaks, minimum heating standards, et cetera. Do you see this happening in a law, or is this delegating to like one or another agencies of the state with instruction?
Well, when we've been speaking with legislator Casey, we saw it being something that was, enacted, a lot of it enacted into statute. That way it's more easily enforced.
Any other questions? Joe?
I'm gonna hold off. I'm just looking at all the temperature triggers around the other states that have enacted something, and it's kind of hodgepodge attempt at indoor, outdoor work clothes required, things like that. So I'll just hold off and do some more reading on that.
Tom, did you have a question?
Well, I was along the same lines, but I would be interested if the bill comes forward to see data to determine what's a high temperature, what's a low temperature, and how to mitigate it.
Okay.
Well, any other questions? Well, thank you so much. Appreciate it. Bridget, you're on. You want to tell us your name and what you're doing, and then give us your testimony.
Sure. Thank you very much. Chair Mahaley, Co-Chair Bartley, my name is Bridget Quinn, and I am the Legislative Director for Joint Council 10 Teamsters, which encompasses all of New England. You just heard some great testimony from Curtis as, really the expert here on this issue and what it means to Vermonters. So first of all, thank you for fitting me in last minute to come up and testify. I apologize. I could not testify in person today. I have to, as soon as I'm done here, get in the car and go down to Rhode Island for another legislative event. So I'm kind of all over the place, so to speak. So with House 348, we really feel that this legislation really shines a light on the need to protect employees, both union and non-union, from extreme heat and cold in the workplaces. We know that exposure to extreme heat can lead to heat stroke, heat exhaustion, heat cramps, dehydration, and can have, permanent, lasting, and unfortunately even fatal consequences. Exposure to extreme cold can result in hypothermia, frostbite, again, can have lasting consequences for workers. So we're really looking to put in sort of basic level protections as our climate is constantly changing and evolving. We really want to make sure that our workplaces are doing the same and that our workers are going to work and they're safe and healthy when they're at work and able to, do the best job they can and then come home safe to their families. So what does that mean? That means that, workers would have access to paid rest breaks, adequate shade, warming or cooling stations, depending on, the weather, and other protections. And we really want to make sure our supervisors and managers are also trained. And this is for all employees, and that they, our supervisors and managers should be trained to recognize the signs of temperature-related injuries. We want to make sure that employers have the appropriate personal protective equipment available, and that, the equipment that they have is actually, maintained and functional. Curtis mentioned the freezing of the eye wash station. And I actually spoke to a worker who, told me about that. And I was kind of really taken aback that imagine, needing to use that. There's a chemical that's spilled, it gets near your eyes, you run to the eye wash station and there's nothing because it's frozen. And surely, we all want to keep people safe. We know employers want to keep people safe. And so that's really the crux of, what this bill does. And as was mentioned just a couple of minutes ago, there's a hodgepodge on sort of like what extreme temperatures mean. And, we are certainly, more than willing and, we want to be able to work with the committee to kind of like really iron out what that means. in terms of like extreme temperatures. And, and what we want the bill to have, going forward. We welcome that conversation and we're really excited to work on this issue because we want to make sure that all Vermonters are safe and healthy in their workplaces. So that's what I have for testimony. Again, thank you for fitting me in today. I appreciate it.
Questions of Bridget? Yes.
And this might be for you, Bridget, or our ledge council in the room. Sophie, in the language, and I'm not trying to put you on the spot, do we have comparisons of other states in New England?
We can get that to
Sophie.
you. Yeah, I mean, the
Okay.
extreme temperature legislation is the same in the states, but I can certainly see what other states are doing as well.
That would be helpful.
Yeah, if you wouldn't mind sending that to our
Yep.
committee assistant, Magali, that'd be great.
All right, happy to do that.
But I'm
Thank you.
assuming, do you cover New England?
I do.
I'm assuming there are other states that do have legislation in New England.
We do, and it's generally the same template legislation. And so, and then it's working with the legislatures, obviously, to like we are now, right? Like, what does extreme temperature mean? And sort of like coming to that sort of place where we're in agreement on what those numbers mean.
Other questions?
This isn't a question, we just have to leave and I don't want to interrupt
Okay.
by doing so, but I just want to thank you all. This was an amazing opportunity. Thanks for letting us sit here and thanks for everything that you do. You want to say
Okay.
thanks, everyone?
Thank
Our pleasure.
Thank you for coming. Do you want to help your son?
Bridget, thank you so much.
Go for it.
Want some candy?
There's so much candy.
Who would say no?
I've got a question like.
Bridget, did she go?
It can take time. It'll take two.
What are you doing now?
We'll be back tomorrow.
Who's your favorite committee?
Thank you. No, I'm okay. Thank you though. Thanks again. Take care.
Thank you.
What were you gonna say?
I was gonna say, last week during the hearing, we heard from Casey Jennings, who was a worker at one of the ski like resorts.
Yeah.
And I think he would make a really good witness for this bill. He brought up the bill during his testimony.
Okay,
I was gonna ask that, somebody had mentioned there was other states in New England with.
she did, and she said she would get us, she'd send us what, apparently there's similarity amongst the states. Sophie, would you introduce yourself for a minute and just answer a question or two?
Please and thank you.
And she'll be there a second or two. You're working on legislation on a draft of this.
I have a draft for the Senate side. My understanding is I can do one for you if the committee votes to take it off the wall, then I can turn it into a long form, but it's drafted.
So you need from us permission.
Right, so as a committee, because it's short form, we have to vote to take it off the wall.
Right.
But I do have a question about that. And maybe the chair and I just need to do some research on our end, but do you know if the committee is planned, or the Senate committee is planning on taking this up this year?
I don't know.
Okay.
So I do think that it would be helpful before we have more testimony to have a bill. And so I guess I would propose I would move that we take this bill off the wall and that authorize Ledge Council to draft a long form bill. Anybody want a second?
Second.
All right. I guess since we've moved it, it has to be Clerk, would you just call the roll? Well, any discussion?
I
No, you're rolling.
think it would just.
Voting to take it off the wall?
Or just,
Do we do that?
No.
It's short.
Is it only because it's short?
yeah, just, I don't think it has to be a roll.
It doesn't, so, okay, well, let me
We
just,
need to vote on it.
we don't need to vote on it.
I think just showing
It's the show of the hands. Who's okay with us taking this off the wall in order to consider a long form bill? Okay.
That's all.
Did you say that you had already, that the Senate already has a drafted bill of it?
They have not introduced it. It's 18 pages. It's with a senator for review, but
Gotcha.
Yeah.
Perfect.
Okay, thank you.
and I did, when there was, I think when it was initially introduced, I don't remember, did I do a walkthrough? Because I do have some data around what other states do currently. The impression I had from the testimony before was the same draft is being circulated in New England, but I'm not familiar with the status of that. But I do have information about other states.
Well, why don't you tell us?
Yeah. Yeah, so just briefly, OSHA, the Federal Occupational Safety and Health Administration, began rulemaking in 2021 on extreme heat. They issued a proposed rule last summer, July 2nd, 2024. The comment period ended January 14th of 2025. There's a public hearing scheduled for June 16th, 2025 on the federal bill. It's not currently, at least when I was looking at this last, which was a few weeks ago, it wasn't clear what was going to happen with that, whether it's going to be halted or whether it will move forward. But it only applies to heat, extreme heat. It would apply to all employers, and it's triggered when employees are exposed to temperatures over 80 degrees Fahrenheit for more than 15 minutes, any 60-minute period. California has an administrative rule. Their heat standard is applicable to both indoor and outdoor work sites, 82 degrees Fahrenheit for indoor, 80 degrees Fahrenheit for outdoor. It requires access to fresh, potable, cool water, access to cool down areas and shade, monitoring workers taking heat-related rest, acclimatization for new employees, which Curtis had mentioned in his testimony, and providing training and requiring employers to maintain a heat illness prevention plan. Colorado has an administrative rule that applies only to agricultural work sites and for heat only. And that's been in effect since May of 22. And that applies when the temperature is or is forecasted to be above 80 degrees Fahrenheit. Again, drinking water, adequate shade as close as practical to the work site, and training. Minnesota has an administrative rule that applies to indoor work sites. And that is, the heat exposure there is for 77 degrees Fahrenheit for heavy work indoors, 80 degrees for moderate work, and 86 degrees for light work. They also have for cold exposure, 60 degrees Fahrenheit for heavy work and 65 degrees Fahrenheit for light to moderate work. Oregon has an administrative rule that's applicable to indoor and outdoor work sites. For indoor, the heat index is for 80 degrees Fahrenheit, and you have to provide rest or light work at 90 degrees Fahrenheit. Again, an acclimatization plan, a heat illness prevention plan, supervisor and employee training. And then Washington State has some rules applicable to outdoor work sites and certain professions. So they have specific rules for general industry, agriculture, firefighters, fire departments, wildland firefighters. I won't go through all those, but similar provisions. So those were the ones that I was aware of when I was looking into this, when I got the short form request.
Thank you. Any other questions at this time for our council? Thank you, Sophie.
All right.
Thank you, Sophie. All right.
Do you have a copy of those notes? I mean, I'm just curious to keep the comparison.
Can I ask a question if anyone knows? What's a fine for idling?
Good job.
You mean, why is there a?
No, I know why. Like, what is the fine
I
for
don't know.
idling?
I don't know.
It's statewide now. It
Yes.
used to be just cities by city.
No, it's statewide.
I don't know, I should.
It's $200. I'm not positive.
I've never been fined for idling.
I mean,
I don't know if anyone ever has.
I will also them.
It's on the books, yeah.
I'm pretty sure it's never been. I mean, the cops idle, so.
If it's cold and there's somebody in the vehicle, it doesn't apply. If you leave it idling and you go in the store for 20 minutes, that applies. But if you're in the vehicle or somebody is sitting in there staying warm, you can.
Depends on how.
It sounds very authoritative.
He sounds like he knows.
All right. First offense, $10. Second offense, $50. Third or subsequent offense, $100.
No, into it.
Oh,
I do know that at our elementary school, we have somebody patrolling people idling during.
I wonder if anybody.
Really? Are you kidding?
I have somebody patrolling that patrol.
I mean, was there? Again, I wanted to ask.
You don't want them,
Okay.
yeah, sorry, or I don't want them to have to ingest a whole bunch of exhaust, but.
Thank you, Curtis.
Thank you, Sarah Carpenter.
Sir Carmichael.
My card, they don't, I don't. think it's-
No, it just sits there, sings when you put it in reverse.
Those temperatures, my car doesn't start.
So we are now going to take up H 169, which is our citizenship,
Wait, sweating.
our citizenship bill, citizenship and
If you're some calories.
Well, I have Parkinson's.
this has to do with citizen, remember? Citizenship
This bill.
and immigration status and public accommodations and housing. Where we left off last time, as I remember, is that Cameron had produced for us a version of the bill, which was a revised version. And then we had, after he presented the version to us, we had, we asked for additional material. And so I've asked Cameron to present to us the very latest, and then that we could have a discussion on it.
And Magali is currently grabbing the printed copies of what Cameron had sent a little earlier today.
Cameron, is this posted on our website now? Let's see.
Chuck.
Yes, one.
It is there.
Sorry, the printer isn't working again, but I had tried to print it for everyone.
But it's on our,
Email.
And I did email.
yeah, 169 draft 2.1.
Yeah. It's under today's date if you go on.
Okay.
Okay.
Are you going to attempt to put it up or?
Yes, sir.
Okay.
I did not bring a physical copy, so yes, I'm gonna share my screen and we will walk through it. Okay. For the record, Cameron Wood, Office of Legislative Counsel. It's April 29th. Believe that you all were just taking testimony on heat in the workplace.
Thank you, Jack.
You can take your year loud.
Immediately fired.
We won't tell anybody.
I will make a comment on that. Mr. Chair, you were mentioning where I'm from. When I first moved to Vermont, and not everybody, but I would get the question often, why in the world would I want to leave somewhere warm like Alabama and move here where it's cold? And I would tell them that they should go into Alabama in July and wear a suit and tell me how it feels.
Oh, yeah. Feeling like this.
It's so.
I have neighbors that move
to Alabama. And they have come back to Vermont in the summer, but they would never, ever complain about the heat.
I'll just tell them, like, if you, whereas here in the winter, you go from heated building to heated car to heated building, you go from air conditioned building to air conditioned car to air conditioned building, so
Please.
anyways.
A good analogy is Washington DC in the summer, having to wear a suit
Yep.
as you go from place to place.
Yep.
And the cars, when you're standing in the streets, the cars are all, of course, air conditioned, so they're pumping out heat.
Okay, so what I have here, what I'm sharing is a draft 2.1. Again, as I mentioned last time we walked through this, this is just, kind of orphan language. It doesn't have any lead in because, still looking for direction from the committee as whether this is going to be an actual amendment to H-169, and if that's the vehicle that you all are intending to use, or, there's been discussion about potentially putting it into S-127, which is your housing bill, because as that came over, it does contain certain provisions from 169. So it's kind of listed here in the heading as a possible amendment to 169, but we'll add in, lead-in language if that's what you all choose to do. Very few amendments to the last time we met. I'll walk through them, and then I had a conversation with the chair just briefly a bit ago to get some further clarity about the expectation of one of the changes, and we'll get to that here at the bottom. But for starters, on page 1, so if you all recall the last time we spoke, this was a change from how 169 was originally introduced. Now this says that in order to conduct a background check or a credit check, a landlord shall accept any of the following. And what we've done is we've moved, or we reordered them. Previously, what was number C in this draft was A. What was A is now C, if you all recall. So that's why I highlighted the A there, just to identify that we've reordered those. And so it's an original or a copy of, and I added an unexpired form of government issue identification. There was conversation last time about making sure that it was valid, and I was a little nervous about putting the word valid in there and the potential unintended assumptions that was made on my part. So I thought it best to just put an unexpired form of government ID. But happy to have that conversation with you all if you would prefer a different word there. But those are really the only changes in B. We still have a residential rental application shall inform an applicant that the applicant may provide any of the above forms of identification. So that language is still the same. So then I'm just going to move it down to the bottom where we're going to get to the next change. This is going to be all the way down on page 6. So now we're in the section that we're in the unfair housing practices section. So this is where we're list all the things that are prohibited in regards to housing. And what we have is, yes, sir. I apologize. I've been a bit absent at times for some stuff. I listen in, but I certainly can't ask questions at that point. In the beginning section of this, one of the current situations we have is that there's a disagreement between landlords charging back for background checks, whether that's considered a fee or not. Rental application. The way this is written, by specifically calling out the background checks, and you're allowed to do that for non-residential and commercial, would that automatically, what's the word I'm looking for, lead to the assumption that the top part of it means that you are not allowed to? I'm gonna say that backwards. Yeah. How I'm interpreting what you're saying. We have subsection A, which says you cannot charge an application fee. And if we're adding B, is it the assumption that because they're in the same section and now subdivisions A and B, that a background or a credit check charge would be considered a fee because they're in the same section? Is that what you're asking? That's how I'm interpreting what you're asking.
Kind of. I'm just saying, like, because we're creating this carve out and specifically calling out commercial and non-residential, does that automatically assume that the top section of residential doesn't get that, like, charging money for a background check? Because it's not you're splitting it apart and then calling it out in one area. You would have called it out in the top section as well if it was allowed.
So the way I read A is you can't charge an application fee.
Right.
You can charge a fee if it's a commercial or a non-residential property. An application fee.
Right. And now we're calling out for a background check.
And then now we're saying that if you're going to conduct a background check, you have to accept some of the following. I don't think the language to me, if I were reading this as a landlord, for example, the background check subsection B, it's not speaking to fees associated with.
Okay.
So I would read it that I can still charge a fee for a background or a credit check. The key is you can't charge a fee to submit the application.
Perfect. Thank you.
That's how I read this section. I will acknowledge that there are landlords that still charge application fees, even though it's specifically prohibited in statute.
And just to understand, so they can still charge a fee if you are renting commercial or non-residential.
Yeah.
An application fee.
Yeah.
Correct. And that's current, that's all current law.
Right, that's unchanged from, right.
Okay.
Did you say residential?
No, non-residential. So like,
Non-residential.
yeah,
Well, not residential.
was that what your question was?
He answered it perfectly.
Okay. So on page 6, again, we were walking through, this is the section where we have all of the prohibitions in regards to housing, prohibitions against certain discrimination. We have this subsection D, and if you all recall, originally it said, if required by federal law, the verification of someone's immigration status shall not constitute a violation of subsection A. There was discussion, and the chair kind of clarified that for me about concerns in regards to if there were changes at the federal level that were to prohibit individuals from being able to lease units to individuals who are not here lawfully in a similar way to how it works in the employment, realm. Individuals, employers are required to validate immigration status of individuals before they employ them. And it wasn't sure that just the verification of immigration status would cover those situations. So that could be a little too narrow. So wanted to broaden it out a little bit to make sure that individuals, if they're required by federal law to exclude people who are not here legally or have some sort of questionable status there, to protect landlords in those circumstances. So I took a look at what some of the other states had drafted up, and I actually have those. I'm happy to share with you all if you would find it helpful, but I thought this was the best approach. So it's if required by federal law, the verification of immigration status or differential treatment on the basis of citizenship or immigration status shall not constitute a violation of subsection A. So in the event that the federal government changes federal law and it would require or somehow make it illegal to lease to somebody who, pick a status. Unfortunately, we're in a situation where even individuals who are even here in a legal status are now being questioned, or that is being questioned. So if there is a requirement to treat those individuals differently, this would state that it would not be a violation of that section if they're required to do that. That's how I drafted it up. This is the first time you're seeing it, so happy to kind of answer any questions. I will comment quickly as you all are thinking. The other change was in subdivision E, as we discussed the last time, that had said creditor. Mr. Chair, you had brought up, it probably makes more sense to associate that with lender, and I spoke with Maria and she was comfortable with that as well. So we just made that change. And if you all recall, this is shall not constitute discrimination for the lender to consider the credit applicant of the immigration status in regards to someone's application for credit, in regards to their ability to repay, et cetera. So, and that would be the amendment at this point.
By way of summary, but with an eye towards discussion. Well, first of all, I felt that we really ought to get to the point where people kind of know how they feel about this, because this may well find its way into the Senate. Well, actually, it's already in the Senate bill. This may become part of the Senate bill is the vehicle for 127, it's 127. As you may remember, there were a number of concerns expressed by various people who would be impacted by this bill. One concern was, don't take away social security numbers that are used constantly. And so that the bill was changed from sort of a prohibition on social security numbers to this list of options. Another concern that was expressed was landlords really didn't want to, I think we're concerned about being caught between evolving federal law and state law. And at our request, this language at the end, which we just went over, has been broadened to make it clear that any landlord, if some of it is very unpleasant to contemplate, but if it should happen that any kind of federal law that required differential treatment, it could be a prohibition, it could be just differential treatment, it could be verification, it could be anything, that all of it's intended to be covered by D as it is now, so that landlords are protected. And then finally, we just narrowed, we reworded ever so slightly E, which was again attempting to get at the concern expressed by for lenders who had specific provisions of federal law. There is, I just want to mention, posted on our website is a letter from a supplemental testimony from Angela Zukowski. Angela, among other, you can look at that, but Angela, among other things, was not in favor of the language at the beginning of the bill, which says that, remember, the first part of the bill, B1, said it's acknowledging that there's going to be landlords may well be doing background checks, which is something I wanted to see. I didn't want any implication that there was any problem with doing doing background checks, and that in so doing, they have to accept this, this, and this. The next section, a residential rental application shall inform an applicant that they will accept any one of those three. In other words, it shouldn't just say social security number, it should say identification and something, whatever they want to put. The reason that Angela didn't want to do. She just felt like it was a requirement that was new and she didn't want to do it. I confess that I'm in favor of that because I think that I'm very much oriented towards what happens in the real world. And in the real world, as I said, I'm now expressing my own opinion. I'm not being expressing the opinion as chair. If a landlord doesn't want to rent to people who are non-citizens or who have an immigration status that's questionable, there's lots of ways they can say they're not renting to them. And let's face it, a lot of these people who do not have any credit history at all. And the landlord can say, well, I'm not going to rent to you because you don't have a credit history and I don't feel good about it. I mean, there's lots of ways that landlords can do that. I think for me, what we're aiming at is landlords who are not, as I said, are either agnostic, like they don't really care one way or the other, or they affirmatively would like to rent to people if they come to them who are, not citizens, and they just thought they couldn't because they thought they had to have a social security number. I think there's lots of people like that. Let me just finish this one thing.
Yeah.
So anyway, I felt like, okay, but where the interaction first occurs is the form. Either it's on the web or it's given to them. And I think that's where the communication has to say, you can do any one of these three things. So that's why I'm in favor of that. But at this point, I would really like to know how other people are feeling about this.
Can I ask a question about, well, if somebody would
Please.
like to react to that, I will wait on my question, but
Well,
I have a reaction to that. I agree with you that landlords can quote unquote find a way to not rent to an applicant. But that's the other part of this bill is not being allowed to discriminate against.
right, I'm just saying practically, I know that's the law. And I think it's there. I'm just saying landlords applying completely neutral qualification, neutral. I'm just saying in the real world, I think it's much more likely that we're doing good here by helping out landlords who are well-intentioned in this regard. That's all I'm saying. I'm not saying it's right, God forbid. I'm just saying it's a practical matter. There may be a lot of financial reasons that people will find they don't want to rent to people who are not,
able to pay.
able to pay. They just say they won't pay, but I don't want to say, please don't get me wrong. I'm just
Yeah, yeah,
being
yeah.
frank. I'm not
No,
advocating that.
Yeah, I know, I think it's totally, I mean, all of our laws are, they live in the real world. Does this language, does having something in statute, in our state statute, end up protecting landlords that currently do rent or anybody who would be like, would this protect a landlord who was renting to somebody who was undocumented? If a federal law, I mean, are we doing anything that would benefit a landlord? How would this benefit landlords?
Someone who wanted to continue to.
Yeah, or begin to, or, anybody.
Well, so right now, to my knowledge, there's no federal requirement or prohibition regarding who you rent your property to. There are, as I've discussed in the committee, there are certain federal dollars where they're limited. If we're going to subsidize someone's, rental payments, and they have to go to somebody who is, I don't remember the exact words, but, legally authorized to be here, I think is the language that's kind of used in the federal statute. The concern, as I understood it, that you all were trying to protect against is in the event there is a change at the federal level that now requires you as a private landowner to validate someone's lawful status here, that we want to make sure, because we're putting in this protection of citizenship and immigration status, we're putting that protection into state law. So we're giving individuals, arguably, we're giving people rights against discrimination that currently don't exist. Because that could then subsequently be in conflict with a federal law if it were to go into place. We want to have this condition where landlords are not going to be conflicted in that situation. If they're required to comply with federal law, you're required to comply with federal law, and we're not going to consider it a violation if you don't. There's nothing in the bill that would say if you landlord, if federal law changes and you're required to verify immigration status and you decide not to because you want to continue to rent to somebody who you've rented to maybe for years, there's nothing in here that would protect someone from that situation. But there's also nothing that the state can do to protect someone in that situation. If federal law is explicit, then the state cannot contradict that.
Right.
So it has to
if
be
it's not,
explicit.
but it has to be explicit.
Yes, yes.
That's why I like the word requires. Debbie.
Well, I was talking to Rural Edge this weekend. And I know we've had testimony from them about the building that they do, but they're also landlords in Vermont. And I just asked them, how do you feel about, not having a social security number And they do background checks on everybody and they use social security numbers. So I don't know, if it would be good to have an agency like that come in and testify how they would be able to deal with things like, is this like, I just don't know because they're a state and federally funded program. I just don't know if they have different guidelines than like just a small landlord would have. But, they go to court too.
We did have testimony from Champlain Housing Trust, which is like Rural Edge. It's one of the neighbor works. And they said they thought they're used to using social security numbers and thought they had to until they asked. And when they asked, they were told, no, we don't need them.
Well, I just know that Rural Edge really counts on them.
Okay. Yes.
So what you had said before about well-intentioned. If well-intentioned landlords don't really need the law, but landlords that don't have well-intentions, they can still get around it. There's no doubt that that's the real world. But does this bill help to increase the possibility of them not being able to get around it?
This is a matter of opinion, but I will say as a general matter, again, I'm expressing my belief, but this is my belief as a lawyer. Yeah, the real world, there's a lot of laws that you can say, gee, if someone really wants to get around it, they can get around it. But one of the functions of law is to lead. One of the functions of law is to set an example, make it clear what the standard is. And the evidence is in almost every area, like in consumer protection, is a really good example. When it's first enacted, it's not necessarily followed all the time. But over time, by putting it in law, you're sort of creating a kind of a standard, and the culture adopts the standard over time. And so I guess I misspoke. It's not just, yeah, you can get around it, but it's not just the well-intentioned landlords, but also ones who, don't think about it. And I think that for me, having this in the law is a good thing.
Or think that they need a social security number.
Yeah, or think they need it, right? Yeah. Joe?
I'm trying to understand you said we think we need a social security, and you said Champlain Housing Trust said they thought they needed a social security. Thought they needed it for what?
For background checks.
Background checks.
They thought they did, and then they realized they were wrong.
I thought they said you get a more thorough background check with one, but there are companies that offer a background check service with other information. It's probably not going to be as thorough, but you can get it.
Right.
Yeah,
But
property
so let me
manager.
just tell you, so because that's
That
a
was what I
big
heard.
question that keeps coming up. So what they said specifically was, well, how much, what we asked was, how much more information do you get than when you do have a name, a birth date, and addresses? What more do you get with a social security number? And they went back to their folks that actually do that work on the applications and do the intake and do the research. And they looked into it and they came back and said, you know what? It's almost not much more. Like though, just having those data points about the person actually pretty much gives us what we would get if we ran a social.
And it's the same company that they've been using, or that you have to.
They didn't look at that company. They just, they must have
They
like.
have an in-house person, I think they refer that. No,
Yeah.
actually, I don't know. Joe, I don't know. I do remember that Angelica
Alexandra.
at Alexandra and Alexandra at, I don't remember her last.
Who works out of California for the American Apartment Owners of America that runs.
Yeah,
means
They
she
do it all the
represents-
time. They have 150,000 members. They do it with date of birth and address, but I think she said that certain kinds of it was a very specific difference. I think she said something like, to go back over the testimony, but I think she said certain kind of criminal background checks, you can't go back as far, or it was addresses. You can't necessarily go back as far, but it was a minor thing. I just can't remember what it was. Yeah.
So our property manager, we have 250 units, but they have many more properties. And we've had 85 new people move in the last 6 years. And when I asked the property manager, they said, it's just as thorough, it just takes longer if there's no social security number.
Okay.
So
Yes.
I have a question. It seems that we're talking about people who have come to the country in the last, well, whatever, 5-10 years. Do these background checks, do they show up any criminal activity outside of the US if they came from, I don't know, Liechtenstein?
I don't think so, but
Do they, or do we don't, it just tells us whether it's a clean record here. If it's only, if they've only been here for 4 months, I would be
Right.
nervous. Let me be not nervous.
Depending on who you use,
That's,
there's a certain amount of states.
It also depends on what country,
yeah, I mean, I'm sure.
because in a lot of countries,
Mhm.
our country is one of the only countries in the world that doesn't have a criminal record requirements. So for example, when I tried to get it, or when I got a green card, when I got a green card in the Czech Republic, there was this sealed tight circle because they needed me to get my criminal record from the United States. And in the United States, you don't have a criminal record until you commit a crime. But most of the rest of the countries in the world, you have a criminal record even without it.
Okay, just happens to be a good.
Yeah.
But there is a record, so, okay. Yeah, interesting. Yeah, okay, so.
Yeah.
Clean. All right, okay.
I do that, yeah. Right? Yes.
I will.
So, I mean, we're hearing, like these big companies doing background checks, and yeah, it takes a little longer, but what about the small landlord that has to, like, they're doing it, if you want to say, like, on their own, and it's taking more time, they're, maybe they don't know how to get the correct information, there's, have we had testimony on that stuff?
I think, but someone else may remember. I think, the associate, what was it? The
I can read you what it says
American-
on their website.
Yeah,
So they have a whole web page that says how to screen a tenant who does not have a social security number. Landlords can take a different tact with tenant screening without a social security number. Some states, such as California, prohibit a landlord from inquiring a tenant's or prospective tenant's immigration status or citizenship and requiring proof of legal residency or citizenship as a prerequisite to renting. Somebody from a property management company that oversees 10,000 units reports her company's policy. And basically they say, according to our spokesperson for a national screening company, a social is not mandatory for a credit check. You can order a credit report with a name and address. When the prospect does not have a social security number, you may get a no-hit response. Before a person is noted by the credit bureaus, a file has to be created, and the landlord's act of requesting a report may be the first thing that initiates this person's credit history. Still, ordering a tenant credit check may be worth a try to see what information might have been reported earlier. So,
yeah, so a number of
So
people.
a tenant background check,
A
a tenant background check does not require social, a full name and date of birth are crucial for determining if you have the right information. Eviction reports are available without a social. Professional property management is a national property management service with over 450 experienced professionals serving over 150 cities in 10 states. And from the testimony that we got, she went through and listed all of the information that you could get with name and birth date. And this kind of just
You're
to
still talking
confirm.
about big organizations.
Well, how does a landlord check a background normally?
Well, from the people I talked to, they use social.
But what do they do with the social?
They run the background check.
How do they run the background check?
I don't know because we don't use
So they can use this service, they can use any of the services that are out there with a name and.
Well, I will ask, because I use a program that's just designed for rentals and they have a section where they'll do background checks for us. So I'll ask them if they would also do it with other documentation.
What did you had us something?
Because if it takes more work.
Yeah, it's gonna cost more.
So-
more work.
Yes. Because once upon a time I did work for a small landlord company and I actually ran all the checks. But we did have a social security and I think it's unfortunate that we would assume that a property management company would be using a program because I don't think that's the reality, especially here in Vermont. And that was going to actually be my other question for Cameron. And this might be an opinion, so if you can't provide it, please let me know. I've had in an instance, actually, as an employer, where background check was run. I knew it wasn't accurate because of what the individual had told me about their background. So then I had to go in and do another background. And I guess my concern is if a landlord says, yeah, sure, I will take whatever documentation that's not your social security, but if I'm going to do that, I want to charge more because hypothetically they might have to run 2 backgrounds or, 2 checks. Would that or could that be considered discrimination?
As long as my immediate reaction thought on it is as long as they are doing that for every applicant, meaning.
Every applicant that's not using a social security.
Right, meaning you can give me one of these 3. And if you're not going to give me a social, then I'm going to have to run a more thorough background check, which costs $10 more. Therefore, I have to charge you $10 more. I don't think that's rock solid though, because an individual could claim that there is a disparate impact on them by doing that because someone of Latino origin may be more likely to not have a social than somebody who doesn't. It's an argument that one could make. I don't know whether that would be successful. I think a landlord who, if they're keeping the cost to their actual cost to themselves, then I think you have a pretty rational basis in making that argument. I can't run as thorough a background check with this information, so you're not going to give it to me, then I'm going to have to charge you X number more to run a more thorough background check. But to me, I think the key would be, are they applying that to every person who doesn't want to give them a social, or are they only applying it to a particular type of person because they don't think they have a social?
Sorry.
You follow me?
Yeah. Okay.
And there's nothing in the bill that stops you from charging the fees to do the background check.
I think it's a question, do you have a reasonable, rational basis for the distinction?
For sure. I think, another concern that I have is just that I was here in this committee last year when we talked about disallowing landlords to charge anything, whether it's for a credit or a background check. That's just the cost of doing business. So it's just a concern that I had. And as we're talking about needing more thorough checks, I figured I'd ask.
And just FYI, that same American Apartment Owners has a link that says order a report for 1995 with AAOA. So just to get a sense of what.
They represent, as I remember, they'll do that themselves, but they represent a lot of organizations. right?
Yeah, oh yeah, I mean, Debbie had heard of them, like they publish, the woman who spoke to us is probably is the editor-in-chief of the magazine that goes out to like landlords everywhere.
And it's not for you.
Don't feel slighted.
Is it, I'm asking you, actually. Is it ever acceptable to do your own background check and bring it with you as part of the application process?
I can't.
Or can the background check only be done by a landlord?
I heard you can.
You mean you bring your own
That's
password
me,
check?
because I
Yeah,
don't.
you bring
We
your
don't
credit
accept it.
with you.
What I heard was that you can have, like what this witness told us was you can submit your information through a secure online link, because there are also laws in a lot of states that don't allow you to transmit a social security number unless it's encrypted, et cetera, et cetera. So there are people who can submit their, like the landlord will say, go on this website and submit your information directly to the background people, and then the landlord gets the report.
Mark?
Vermont is one of those states.
Yes.
What's that?
Hi, Emily.
States too.
And Vermont
Hi.
does allow that.
I have a
Go ahead.
question.
Yeah.
Last week I had asked about enforcement and outreach. I just want to circle back for the committee or anyone on the committee who might have a suggestion or knows. While again, status quo is clearly not always the way that we want to go, and that's why we're here, right? But since this is, I just think about, some folks in my district or in the area who are seniors or others who may not be as connected. I have a former partner whose landlord was, 90 years old and lived in Florida. So I want to know how that would work, the outreach to let folks know this exists. Not everyone is a part of the landlord association that Angela represents, where I'm sure if this passes, they'll do a lot of outreach and let folks know how to comply with the new laws. But I'm just curious how this would relate, and I don't want people to be in trouble for things they just don't know that, and then someone to say you discriminated against. That's what again, I guess that would be a case by case basis with the Human Rights Commission, but since it's been the status quo for so long, and there are, some people who are just one senior person who has a rental and they may just not be in touch with, reading the news or involved. I just wanted to understand more about how that outreach would work, since this would affect a lot of people, and I wouldn't want them to get in trouble.
Yeah, and I'm curious, does anybody know what the last protected category that we added to the Fair Housing Act?
Yeah.
With the last protected category prior to this one?
Yeah.
Homeless status.
Oh, okay. Were you here for that, Emily?
Yeah.
So how did that come? How did that work?
That wasn't in.
That's not the same thing at all. Again, I'm not challenging it, but I don't know how that relates to a like 90-year-old person, like not knowing that they just didn't comply.
When you're looking at the unfair housing section specifically, it doesn't list homelessness. So we have.
So that was only places of-
refused to deny someone
Public
based on
accommodation.
race, sex, sexual orientation, gender identity, age, marital status, religious creed, color, national origin, citizenship, immigration status, or disability. Yeah, or because somebody with minor children. I would need to go back and double check.
You mean what the last one was? Well, I think it's safe to say that every time there's a significant change in the law, there's a real Emily's right, there's a real education issue.
sure.
And one of the things I imagine without knowing, that's one of the functions of the Vermont Landlords Association. You know,
But they can't reach out.
Another-
I'm not saying I'm supportive.
not.
I'm just saying, how can we collectively understand that there could be challenges? I hate the word unintended consequences that we use in the legislature. I wouldn't want, I just want to be cognizant that there could be like I said, like a senior who just like didn't understand and then was like, I've never heard of this. I don't know. I just want to raise that.
I think that that's valid for like all of the things that we've talked, like especially today, like the heat and the cold, like the labor stuff. Of course, we want employers to be informed. And I think that Big spoke specifically about the work that they do around fair housing. And a big part of it was education. So you may not have been here, Emily. I'm not sure. Were
No,
you here when
I
Big-
was, and I've worked on
Okay.
that for a while, and they said actually that they struggle, and which is why they needed to hire more people because the outreach piece had fallen.
Right.
I don't know the
So
last-
I am aware of that.
Okay.
I'll have to go back and look. I don't know the last time it was amended to add a class of individuals, but I do know, and some of you, I believe, were here in this committee over the past few years, you added or you made changes to the definitions of harass, that it need not be severe or pervasive, for example. That was done recently, and I believe last year as well, you added information regarding hairstyles to the definition of race. I believe those two were both done as biennium.
And also the homeless bill of rights, which wound up being simply a discrimination.
So I'll check on that, and I can find out what the other piece was.
And a protected class for public accommodation spaces. I don't know if it was.
Are you sure about the whole purpose of it was?
I know, I think it was for places of public accommodation to have them included as a protected class.
Definitely.
Yeah, I don't remember it pertaining to. Actually, it did come up at one, I think we did have a conversation about it, but I don't remember how those conversations went.
Well, I can easily go down a rabbit hole and find out
I
what
know
we
you
said, but
have, no doubt.
but I'm not gonna do it right now. I'm gonna go get a drink.
But I did just want to add also, I mean, honestly, and in here, even in that same paragraph, it said you can't discriminate against people with children, and we know for a fact there's landlords who will not rent to people with children. I can tell you this wholeheartedly, 110%, there are landlords who do that. There's ways around it. So regardless of what we put in the law, if people really don't want to do something, they're not gonna do it, and they're gonna find loopholes. But I just want to I hear everyone's concern. And I want us to do our due diligence, so like continue your conversation, and at the end of the day, and also, it's gonna be what it is. Because back to that enforcement and an accountability piece. And like to answer your question, that 90-year-old person who doesn't know, you know.
I mean, yeah, there's a lot we need to do for that person.
Right,
Yeah.
or whatever the case may be, and that's, and also, that's sort of the way we find out things, right? It's like, is it a thing if they didn't know, and it's, oh, I didn't know. And we address it and move on, as opposed to it being the intent. The whole purpose of a protected class is to prevent intent of the harm. So if it's someone who, I can guarantee you 90% probably, I mean, unless there's some really, I can't guarantee anything, but I can just, in my heart, I can't see someone holding a 90-year-old accountable for discrimination when they're like, I did not know that this was not a thing. But in the event that does happen, I mean, I don't know. It feels weird. I don't know.
It's, what's the pleasure of the committee? It's getting time for a break. Do we want to, are we in a position to do a straw poll? I'm not gonna do a vote on this, because it may just go into another bill. But the question is, are we in a position to do a straw poll? Shall we wait a day or two, whatever, but did you, yeah.
Can I actually
make a recommendation, and if
Sure.
I am in the minority, I'm totally fine with that. And understanding that we're kind of up against the legislative calendar, I might actually recommend keeping H 169 on its own, and then just to ensure that we can get S 127 out by this week. Also understanding that it has the TIF language, or should have TIF language, and I'm not sure where Amy's committee is. I think we have more work to do on our housing bill. And I might.
Is housing bill 127?
127 is our housing bill.
I just want to make sure I
Yeah, I know.
what you meant, but.
So it is true, we have a lot of work to do
Yeah.
on the housing bill. It's also true that we have to get it to Ways and Means, but we have to get effectively, we have to get the housing bill out of here by Friday and close the business. Because then it'll go to the floor on Tuesday, be referred to Ways and Means, which will start hearing it on Tuesday. And then it has to go to appropriations. Then it goes to the floor again. Yeah.
Can I would also suggest in some comparison, in the space where there's a placeholder for this in this language in S 127. I would like to see it placed in there, and then we could how the language would be in there so that we can focus on working on S 127. And as we're working on it with that language in there, we can tweak we can deal with that and play with that as it comes up as we're going through it, and then do it accordingly on our housing bill, because there is a placeholder for it. So
there is a placeholder for it because the Senate language on this issue is in there. So either by Friday afternoon, we either have to strike the Senate language and leave it out. That would mean 169 would have to go on its own, or drop 169 in. I think we, as a
And
practice,
169 essentially would die for this session because there's no way it would make.
it really
It
depends.
didn't go.
It's likely that that's the case, not certainly that that's the case, because 169, well, first of all, it wouldn't die in the sense it would stay on our wall. But if we, let's say that sometime next week, whatever, we passed 169 out of here onto the floor and it was voted out, and it would go back to the Senate. I think it would go to Senate rules. Remember, the Senate, it's after crossover.
Right.
The only meaning of crossover is that instead of their having to take it up, it goes into this little box in the Senate, which is presided over, the box, by Senate rules. So what would have to happen is Allison Clarkson, Senator Clarkson, who's the chair of our analog committee, would request of rules that they take it up. If she did that, well, then they take it up. And then the question is, do they have time to deal with it? Would they? If they didn't, Cameron, do you happen to know? If we didn't vote it out of here, it's still on our wall. We could vote it out early next.
Before crossover.
Yeah, oh, well, yeah, we could just take it up right away. It could be one of our first bills if we wanted to. What if we do take it up and it's passed out of the House and goes over to the Senate? But they don't take it up. Is it still there?
Mhm.
Okay,
They would be able to take it up next year.
They'd be able to, but would they have to?
no,
Well, they don't have to
They don't have
take,
to
same thing like you
anything.
don't have to take anything.
All right.
Representative Krasnow is waiting to speak.
yes, Madame.
Thanks, Joe. And I wanna say again, I think there's two conversations here, and I do support the bill. I just wanted to say, on behalf of some constituents that, I just wanna, like anything that was mentioned, it needs a lot, it just when we change things, and I take that upon myself to educate my community. And I hope others would as well. I think the other conversation that our chair was saying is how folks feel. I think those are two straw polls of how folks feel about incorporating into the housing bill. So I would like to make sure that we make time for both those straw polls to figure out, because people may feel differently about one or the other and not both.
Good point. Okay, my question of you guys is, do you wish to take either of those straw polls now, after we take a break? Or do you want to wait until Thursday or Friday to do it?
I say we just do it now. I mean, it doesn't take long to do a straw poll.
Sure, let's do it up.
I mean, we've taken weeks of testimony
Yeah,
on
no,
this.
no, we have taken a long time. I wanted to give people a chance to think.
Well, yeah, if somebody want to do a straw poll on straw polls?
Okay. Oh, you need more time. Do you need more time? Are you ready to vote? If you're like, I mean, like, are people ready or do people need more time? Do you need more time?
What is the question? Whether to
There are
take it
two
up?
questions. Should we have a straw poll today on A, to the extent people have feelings about keeping it separate versus dropping it into the housing bill?
Oh,
Which
that's
is-
the first question.
That's
Oh,
one.
okay.
And then the other is, what's your feeling about the bill as it stands? Those are the two questions. The only reason I would wait is if there are any substantial number of people here who say, gosh, I'd like to think about it a little longer. But I think it's true, we have had this with us a long time. So my question then is, how do people feel? Shall we take a straw poll now? Remember, straw poll is not final, but shall we take a straw poll now?
Yes.
Yeah, let's do it.
Let's do it. Okay, all right. Here's one where you don't have to vote, but if you have feelings, how many people feel that it's best if we leave it on its own and we don't drop it into the housing bill? 1, 2, 3, 4.
And Emily.
You can't vote.
Emily, 5.
Sorry.
How many people feel like like to drop it in the housing? 2, 3, 4, 5. Well, that's nice. I guess I'm the deciding vote. All right. Second of all, how many people feel comfortable with the bill and want to vote yes on it?
A separate, or the language
Yeah, the language.
As it is today.
Yeah,
with Cameron's edits and with the compromise on.
yeah. 1, 2, 3, 6. 6? You.
Yeah, for straw poll.
7.
Yeah.
So this
Because
could change. 7, okay. No,
I don't know. I need more time.
okay.
You should have said so. We already asked.
I already said I needed more time. I didn't think I needed to, again, say I needed more
Okay, how many
time.
firm vote, how many people at this point how many people at this point, knowing what they know, are no?
Current language, I'm gonna.
Yeah, 2, no, okay. All right, okay. That's fine, that's okay, all right. You want to know whether you can get out of here?
No, I was gonna say, I can give you some information.
Oh, my God, yes.
Information.
The last time the section unfair housing was amended to add a particular subset of individuals was in 2019. And it was amended to add persons who are a victim of abuse, sexual assault, or stalking.
That's right.
I went back as far as I could on the internet and couldn't find it. There were some other slight amendments. They changed the word handicap to disability and a few other things, but I couldn't find another group of individuals being added going back to 2013. So it would have been before that, but.
All right, listen, everybody, listen. I don't want to keep people too long, and no, we're not I'm not saying the A word yet.
I'm not
Okay.
even paying attention.
Okay.
Accusation.
I just want to tell you guys, we're gonna hear 127 tomorrow. To the best of my knowledge, first Rep. Marcotte and Rep. Branning will come in and present the bill. Then
The chip,
John
great.
John will come in. Okay? John
That's
Gray.
their ledge.
Yeah, but John, one of the problems we're having across the building right now really is that John Gray is being overbooked by a factor of 2 or 3. And so it's holding up, it's actually holding up things because there's only one John Gray. Anyway, so you should consider yourself lucky that our council has always prioritized us. Anyway, so they're gonna present the bill, and knowing John, it's not gonna be quick. That's not a criticism of John, he just tends to be very thorough. And there is a possibility that we will, in the ensuing day or two, take a testimony. There are issues that they did consider and issues they didn't consider very much. And there have been requests of us that we consider. And so we probably will be dedicating a substantial part of Wednesday, Thursday, and Friday. If we are to keep this thing moving, Ways and Means is ready for it on Tuesday, which is why I say that if we can vote it out, we should vote it out. Whatever the vote is, and with whatever's in it, we should vote it out Friday. Okay? And so it's going to be, I think it's, and we have other bills. We have 125. We have, it's just going to be an intense week or so where we have a lot to get moving because, we have a month, but we have to, particularly bills that have a lot of stops to make. 125 doesn't, but 127, our housing bill does. Yeah.
Are we going to add into the language about stalking, victim of abuse and domicile status?
Here.
This
Our
is the
bill
statute.
currently, the statute
The
that
statute we
exists
currently have
already
all
includes those, that.
He was
that's
just
the
saying
last
that the
time
last
we
time that
updated.
something was, he'd been asked the question, well, when was the last? Remember, Emily was saying, hey, we have to make sure that people understand what the new law is. And that takes education, and we should all take that up. And then, so Cameron was asked, what was the last time that we added to the bill? And that was it. Okay? All right, everybody. Anything else? 9 o'clock tomorrow. 9 o'clock tomorrow is going to be hearing on, all right? So we are adjourned.
Shit.